Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. And this is our bi-weekly community conference where all are welcome to participate. We ask people to post their questions beforehand, and where to post the questions, the links are posted on immigration.com in the tabbed control on the top right, as well as you will find tweets from me. Um, it's on our Facebook page as well, on Google Plus as well. So basically, we'll go over your questions. I'll go over the frequently asked questions first. Then we'll do other posted questions, and if time remains, we'll do new questions from people who just logged in. I think we'll have time to do new questions today. Okay. Um, by the way, as I'm talking with you, I'm also looking at my Twitter feed. If you want to tweet to me, my handle is immigrationcom. Immigrationcom. I'm looking at my tweets. You can also tweet to me from immigration.com homepage. In the right hand corner or the right hand margin, you'll see that there's a Twitter feed. You can tweet to us from there. Um, we are very active on Facebook as well as Google Plus. So feel free to contact us, but as we are talking live, Twitter may be the easiest thing to do. Okay, let's get started. You've heard the usual disclaimers. This is not an attorney-client privilege telephone call. This is being recorded. This doesn't create a relationship. You don't owe us anything. We don't owe you anything. We try the best we can for you. But that doesn't mean we are infallible. This is a relatively short conversation. Okay, now let's look at the first frequently asked question, which I believe to be a frequently asked question. So the question is, if I have my I-140 approved, can I carry that priority date across many different companies instead of just one or two companies? And the answer is yes. You can, once your I-140 is approved, there was some doubt about whether if it is then revoked, do you lose your priority date? And USCIS said, no, we would let you keep it. Nevertheless, if you are allowed to keep your priority date, then it belongs to you. Wherever you go, whether you change 10 companies or 10,000 companies, the priority date remains your property. It remains attached to you unless it is revoked, unless your I-140 is revoked for some kind of fraud or an erroneous approval, the priority date will follow you wherever you go. Okay, so let's look at the questions that were specifically posted under this frequently asked questions. Two questions: I-140 revocation and priority dates. How many times and how many companies can I port the same priority date? Unlimited. Number two question. Well, basically, one of the questions here was, and that I think is also an interesting misunderstanding people can have. What if I change from company A to company B and company B uses my priority date? If I go to company C, can I still use the old priority date? And the answer is yes, of course. The priority date is not an exhaustible amount. You can use it as many times as you want to. It is not a perishable asset. Okay, so just because it has been used by one employer or 2 or 10 employers does not mean you cannot use it for the 11th employer. That's not a problem. The second question was, what do you think, when do you think I-140 EAD rule will become effective? I do not know, sir. The problem is that's a regulation that has now been pending a very long time. USCIS went through the time and trouble of publishing the regulation, then taking in 50,000 plus comments, and obviously they must have been reviewing it. Now the question is, when it's going to be published? We don't really know. Is it because Obama administration is leery of starting another litigation that they're not doing it? I do not know what the problem is. There is no news yet of when the regulation will be published. So because it is that situation where nothing is predictable, I cannot really give you good advice about whether you should wait for the I-140 EAD rule to become official. I don't really have any good thoughts on that because we don't know when the rule will become final or if it will become final. Okay. Anybody has any follow-up questions on what I just discussed? Press *5 on the phone. Any follow-up questions on this issue? Press *5. Let's go on to the next frequently asked question. There's nothing. J1 holder getting married to a US citizen. This is a tricky situation, as most J1 holders and their spouses or their spouses to be should know. What happens is, if your J1 has a home residency requirement, 212E, you are not allowed to get a green card or work visas except O1 visa. And I think E3 also is acceptable. Except those two visas, you cannot get any work visa or a green card until you get the 212E home residency requirement either waived or you comply with it by going back to the country of last permanent residence. Okay. So one of the key issues is, now here what is happening is we've got a spouse, her husband is German but a resident of Sweden, I'm American, he was here, he's here on a J1 exchange. Can we apply for adjustment of status now while we are still waiting for an answer on the advisory opinion? And that's a very tricky issue. On one hand, you could argue that applying for a 485 is not the same thing as getting an approval. So you, of course, cannot be approved until you have a waiver or an advisory opinion from the State Department that clearly says he is not subject to home residency requirement. Okay, so obviously, without the waiver or compliance or determination that he is not subject to the 212E requirement, you cannot really get a 485 approval. Can you file a 485? I think that's tricky. What I would do is, if I were you, I would contact your local congressman's office, ask them to find the answer to this question from USCIS. The reason I do that is because if tomorrow USCIS says, no, you shouldn't even have filed the 485, and they have given a different answer to the congressman, you might be able to get some kind of a redress, maybe not an approval, but at least some kind of a redress from the government. Maybe a fee refund, I doubt it, but doesn't hurt to try. So contact your congressman, have them find out whether you can file the 485. I don't think you should. I think it's problematic. Might as well just wait. Then next question is, does he need to get a waiver first? And the answer is the same as getting a determination. I already answered that. Can we apply for 485 before we get a decision on the waiver? And the answer is no. Again, no, and not no, but I don't think it's a good idea. We are worried that his J1 visa will expire before we get a decision. Well, if his J1 expires, please have a consultation with the lawyer one-on-one. Make sure they go over your facts. But generally speaking, there is then a 30-day grace period. And for somebody who wants to get ultimately a green card to USA through a US citizen spouse, up to 180 days of unlawful presence also is not going to hurt their case. But over 180 days, then there could be issues which I would want you to avoid. If there was no J1 problem, then even if he had been unlawfully present for years and years and years, as long as he entered the USA legally, which he did, getting married to a US citizen and getting his green card within USA would not be a problem. But when you have a 212E home residency requirement, then it is not advisable to go beyond 180 days of unlawful presence. Of course, I would prefer for you not to be unlawfully present at all, but these are some of the things that you have to balance out. If you are on the phone, press *5. *5 if you have a follow-up question for me. 1 second, let me get to you. I see your hand up. Go ahead, I can hear you. Go ahead.
Yeah, sorry, this is the poster that posted the question. So thank you very, very much for this
Of course.
information. It's very helpful.
My pleasure.
Our biggest concern is really the expiration period at this point. And I understand what you said about the contacting the congressman and also, speaking to a lawyer if we're getting into this issue. If we see on the State Department website that we've received a no objection letter from the home country, and we're just waiting for the final determination and approval from the State Department on this, is it something we could do then to apply for the adjustment of status, or we really have to wait till the final approval comes through to apply for the adjustment of status?
The final waiver, actually, because the problem is anything less than a final approval is merely a work in progress. It's not final action. It does not clear him of the 2-year home residency requirement.
Okay.
Okay?
Okay, thank you.
You're welcome. Good luck.
Thank you.
Bye-bye. Somebody else had raised their hand up, and I am putting that down because I'm pretty sure you don't have a J1 related question. I am only doing the posted questions first. I will not answer any questions other than the ones I invite on the topic that I invite them on. So new questions will have to wait till the end of the discussion. Okay. Now, going on to the next frequently asked question. H-4 EAD when I-140 approved through a future employer. USCIS has made it very clear. They said, look, we don't care whether the I-140 approval came from the current employer, a past employer, or through a future employer. As long as there is one I-140 of some kind approved, your spouse can get H-4 EAD. So it does not have to be any specific employer's I-140 approval. You just need one unrevoked I-140 approval. I hope that makes it clear. Any follow-up questions on this issue, press *5. Nothing new, please. Follow up on this, *5. Next question is about automatic visa revalidation and H-1B amendment. Let me take a second and explain to you what automatic visa revalidation is. So let's say you are here in the USA on F1 visa, and then you did your OPT, then you got your H-1 approval. You've got your I-94, let's say it's October 15th, and you want to go to Canada or to Mexico or to, I think, Virgin Islands for 2 weeks or 3 weeks for a vacation. Do you need a visa to re-enter the United States? And the answer is normally yes. But when you go to the territories that are attached by land to the United States, you are not required to have a visa if your trip is less than 30 days. That's called AVR, or automatic visa revalidation. So if your trip is less than 30 days and you don't have a US visa, you need a Canadian visa to enter Canada. But to enter USA, you will not need a visa. That's called AVR, automatic visa revalidation. In this case, the case that has been posted, I traveled to Canada on an expired visa using AVR. I moved to a different state. Now, they are on H1. Can I travel again to Canada under AVR? Can I travel monthly? Well, first of all, there's no limit to your number of AVR travel entries and exits as long as each stay is less than 30 days. But you have other problems. If your H1 is not properly approved, you are working in a location other than for which the LCA was approved and amendment was approved, you will have a problem because you are in violation of your status. And if that comes up, AVR is a separate issue. Because you're out of status, your I-94 is invalid, you may not be allowed entry back into the USA. Every time you change project substantially or change job location beyond normal commuting distance, you probably have to do an H-1B amendment. It is left best to your lawyers to decide. But without that, you would be considered to be out of status. So AVR does not help you if your status is at issue. Okay. If you're on the phone or if you have a follow-up question on this, press *5, please. *5. Another question that comes up quite frequently is, look, I'm not getting along with my wife. I want to withdraw her 485. Can I do it? And the answer is, well, yes, you should. You can send a notarized letter to USCIS saying, I no longer support this petition. You can also, in the same letter, state that you withdraw the affidavit of support and then follow it up with a phone call to make sure some action has been taken or your withdrawal has been noted, and that pretty much takes care of the issue. But do remember, this can create a problem for your lawyers. See, what happens is, if I represent both the husband and the wife in the 485, and one of my clients says, I want to withdraw her case, I cannot do it. I cannot even advise it. I cannot advise one against the other. So it can become potentially problematic for your lawyers, and you may have to get another lawyer eventually. But other than that, there is no issue in withdrawing the 485 of somebody you are not going to support. *5, if you have a follow-up question on this, *5. Okay. All right, those were all the frequently asked questions. Now let me start with the normal questions, and after that we'll take new questions. Let us see. From Yeber, I'm currently on company A's H-1B, which is good till August 2019. I-140 was approved, EB2 category with company A, same company. Now I want to join company B after giving the notice to company A, I guess. Company B will be doing my H-1B using company A's approved I-140 to file my H-1B as I'm beyond my 6 years. Okay. Number one question, can company A withdraw my I-140? And the answer is yes. They can write to USCIS to withdraw the I-140 or revoke, whatever name you want to call it. And USCIS will revoke it based upon the request of the employer. Can the priority date be retained? And I have mentioned this many times. I also have a blog entry on this. You can read the blog entry. USCIS has flip-flopped on this issue quite a number of times, but now they have said that their policy is they'll let you keep it. The priority date won't be taken away based upon an employer's request to revoke your I-140. There can be other reasons, but not employer's request. So, and there's also a regulation pending which will make it even better for you. Right now, we don't know where that regulation is. So what happens to the H-4 EAD? And we've talked about it many times. If you look at our frequently asked questions. Question is, I've got my wife's H-4 EAD. What if my I-140 is revoked? And the answer is, government has said in those cases, they reserve the right to revoke the H-4 EAD. Will they do it or not do it? We don't know. They reserve the right. Okay. Ray, if you're on the phone, press *5 if you have a follow-up question. *5. Okay. Next question is also from Yeber. Sorry, I didn't need to answer this question actually. He said he had already seen my answer because he had posted in the last call. Okay, well, doesn't hurt. Next question is, we are in EB3 India category, priority date is 2005. Husband, who's the primary, received an RFE for medical exam, but we haven't received any RFE yet. Should we send medicals anyway? I think what you should do is follow it up with the USCIS customer service. I don't think they recommend sending in the medicals without an RFE, but do discuss it with them. Let's make sure that your cases are on track. I don't think you should submit without an RFE. Let me double check it. Sumanji, I have a quick question for you. I'm on the call.
Suman just went for a walk.
How about anybody from the 485 people? Bharti is there? Okay, just tell her to buzz my extension, please. Yeah, I'll get to it. If there is a, I don't think this is something you should send your medicals without getting an RFE. Bharti ji, if we have a situation where husband who was the primary has received medicals in the RFE, request for medicals, but spouse and children have not, do we advise people to send in their medicals anyway, or do we advise them to wait for the RFE? Thank you, that's what I thought. Thank you. Yeah, you wait for the RFE, that's what we advise people. Okay, any follow-up question on this star 5, please? Okay. Then we go on to the next posted question. Our employer-based green card got approved for 10 years recently. Any important next steps we need to take while converting to green card from H1 and H4? Just the people who are working should present their green card to their employers and update their I-9s. It's not difficult to do. There's no procedure for traveling. You just need your passport and your green card. You should wait for changing employers. I have a bunch of blog entries on that as well. Please review those, and if you still have any doubt, because I don't think 6 months employment is a magic number. Really, the bottom line is on the date you took the green card, what was your intention? And even that might have gotten diluted because of the AC-21. And I've discussed this in detail. So star 5, if you have a follow-up question, star 5, okay. Once I'm done with these, then we'll start with the new questions. Manglesh says, labor has been filed December 2015, not received anything from the Department of Labor. H1 last date is August 2016, okay. My employer have filed after 2 months and 9 days. Okay, not sure what you're saying, but what you're saying is, can I go to F1 status and can I come back onto H1 if my labor is still pending? And the answer is sure. Both of these things are possible. If you have gap between your H1 expiring and becoming eligible for another renewal, you could go on to F1 or even tourist visa. But whether they will give you the F1 or tourist visa is, of course, their discretion. A lot of people go on to student visa and get CPT. See my blogs. I have in the last 5-6 entries a very detailed entry on what to do with the CPT. So look at that. Okay, that's also an option. But going to F1 back to H1, that is not a problem. Don't worry about the to and fro. That is not an issue. I think you are on the. I see your caller ID. I think you are on the phone. Go ahead. If you have a question, press star 5. I think I see you. Somebody with your same first name. Okay. Mangleshi, go ahead, please, Mangleshi.
Yeah, so I can come back from F1 to H1, still my labor is pending, right? Because I have
no problem.
That 1 month.
No problem. See, it is not necessary for you to be in H1 status for your labor certification to continue. In fact, you don't even have to be in the United States for your labor certification to continue. You can be outside US.
Okay, but if I am in United States, then that is good option, right?
Well, it doesn't hurt you, but it doesn't help you either.
Okay.
Okay.
Okay, So I can come back on H1 means like from F1 to H1, right? That's only.
Yes, sir. That is not a problem.
Okay, so that's not going to create any issue, right?
I don't see any issue here. As long as you don't make any misrepresentations to the government, I would advise you don't use student visa as an excuse. Go through with the course, whatever course you are taking. You can, of course, do it part-time. On H1, you can study part-time, even actually full-time, as well as your job. So what I would suggest is if you take F1, and then when you get back on H1, continue your course. You can drop the number of credits. You can study part-time, but at least you shouldn't just convert to F1 to maintain status.
Okay.
All right?
Okay. Thank you, Raj.
You're welcome. Good luck. All right, let's go on to the next question from B. Sundar. Approved I-140, H-1B expiring in March 2017, trying to obtain jobs within my company, at least 50%, 51% same as my previous job. This is my understanding on what needs to be done. Change jobs, amend H-1B, may or may not be needed. It depends, Mr. Sundar, whether the jobs are substantially similar or dissimilar. But if they are quite different, then yes, H-1B amendment should be done. And I will get H-1 extension for 3 years. You should be able to get H-1 extension for 3 years if there is less than 6 months remaining. What happens is when you have more than 6 months remaining, USCIS has been very inconsistent about giving people all the entire 3 years. Sometimes they end up giving you whatever the time remaining is, although they are inconsistent. I would expect to get 3 years. I hope that they are getting more and more consistent in their policies, but that 3 years is by no means guaranteed. You are entitled to it. Eventually, when there's less than 6 months left on your H1, if the I-140 is still unrevoked, you will get your 3 years for the next time around. So far you're right. You will have to refile the perm, correct. What do I have to do if I switch to a new employer? Exactly the same thing. Can they use my approved I-140 and get H-1B extension for another 3 years? The 3-year rule being the same, inconsistent, but yes, it is not necessary that I-140 must be approved through the same employer for whom you are getting your H-1 extension. So yes. And they can use, in those 3 years, they can start perm and I-140. This happens all the time. If you are on the phone, Mr. Sundar, and you have a follow-up question, or anybody has a follow-up question on this issue, *5. Okay. Oh, there is. All right. Let's go to. Go ahead, sir. I can hear you.
Hello.
Yeah, messages.
Yes.
Yeah, go ahead.
My mother-in-law is visiting me.
Stop. I'm not taking new calls right now. Sorry. No new calls right now. I'll take that at the end of the discussion. Okay. J1245, my I-140 approved in EB2. There was an error on priority date. I've got the amended approval notice with valid priority date, changing employers. I read the article on proposed regulations. Which day I count to count 180 days? Look, first of all, we don't even know if that regulation is going to be passed or when it is going to be passed. So I don't want to guess, but normally the way the regulation was written, as I remember it, it said that as long as your I-140 stays unrevoked, it remains unrevoked for 180 days, you are good, and the time would probably be counted in your case from the first approval. The amendment is merely an add-on, so I don't think that's an issue for you. But whether or not that regulation is going to be seen soon or at all, we don't know. *5 if you have a follow-up questions on this issue. No new questions, please, guys. Follow up on this issue. Okay. Anirudh Bhardwaj says, I have a relatively simple but important question to ask you. Suppose a Canadian citizen who was living in the US and got deported back to Canada and they have no residence or family in Canada, where does he stay? That I do not know, sir. I do not know where they would stay, but obviously guessing what the most countries' requirements would be, for you to stay in that country, you would have to have a legal reason. What are the legal repercussions faced by this person? If you're asking about Canadian law, I wouldn't be able to guide you because we practice on the US side only. As far as coming back to USA for somebody who's been deported, I think there's a minimum 5-year bar, but depending upon what the ground for deportation is, it could be even a permanent bar. For example, if somebody is deported for an aggravated felony, they can never come back, or visa fraud, they can never come back. It's very difficult to get waivers. I think for aggravated felony, there's no waiver. For frauds, there is a waiver based upon a US citizen or immigrant spouse, if I remember correctly. And there are so many rules and sub-rules. *5, Anirudhji, if you're on the phone. *5 if you have a follow-up question. Okay. Applying for citizenship, need to file N400. I had an arrest in 2003, and the case is stepped. I do not know what step means. This is local lingo. I do not know what that means. It was later expunged. Now I cannot get any paper or certified copy from court. Original document was attached with 485. I have only copies. Just attach the copies. Because the government has those in their possession already, at least there is a good chance they're not going to trouble you about it. Okay? And it's not like you are goofing off. Despite your best efforts, if you're not able to obtain a document, the copies are as good as the original. You just have to document that you tried to get it and you couldn't get it because the document was unavailable, record was expunged. So you'll be fine. Any questions on this *5, please? Okay, here we go. Florida, go ahead, Florida.
Yeah, this is the time I asked this question. And this STET is the undefinite time postponed. It will be never come for hearing, never come for any processing. And they said it can be open by any end in 3 years, and that is already finished 3 years for last 2003.
Okay.
So in 2007, we expunged this case and they closed everything.
Okay, I've got the facts. Hang on. Yeah, what is the question? I already answered that you can use copies as long as you tried your best to get the records. You'll be fine. What is the question?
What I should write? I don't have copy, or because court doesn't give me any letter. They just stop on the phone because.
Yeah, you can definitely write to them, write in support of your N400 that you tried to obtain the copy and you were told on this date at this time approximately when you talked that they don't have any record of this.
Okay.
In the meantime, while you file this, also make a formal application. There must be a formal application to obtain a copy of your record. Let them send something in writing that says no record exists.
Okay.
Okay?
Okay.
Good luck.
Yeah. Thank you.
You're welcome. And I think we're coming close to last couple of questions left, I guess. Yes. Then we'll start the new questions. So Harish ji has a question about mother who's 83-year-old coming to USA, how to apply for a green card. We have done a bunch of, he's a US citizen. We've done a bunch of calls on this issue. And my only concern has always been, if somebody enters in the US using a tourist visa and says at the airport, look, I'm coming in for a visit, but it is in their back of their mind that they want to convert to green card, that could be considered to be fraud. If, however, they enter USA, no intention to convert, 3-4 months later they change their mind, they can file green card, no problem at all. So don't have that preconceived intention. If you do it through consular processing, of course you can. It might take about a year and a half. There is no other faster option. My only recommendation would be just don't have any preconceived intention. Let her arrive, wait a few months, have a discussion. If she's inclined to file a green card, at that point, if you change your mind and file a green card, you should be okay. But don't have a preconceived intention. That is problematic. And like, carrying your papers with you or selling your property in India, none of that is a good sign for these applications. There are plenty of people who had no problems, but we have dealt with issues where government raised these problems. *5 if you're on the phone and you have a question. *5. All right. Passport correction. Oh, you are here. Yeah, Harishji, go ahead. I can hear you.
Thank you. So I think it's better for her to come here without, the intention.
Right.
I agree. We're not sure if she wants to or not.
Right. Right. Have a discussion with her at least 2-3 months after she left, and then decide. Okay, you know what, Mom, I think you want to stay here. You should stay here. I'll tell you something. I have seen that Indian parents usually are not inclined to move. It's very difficult for them. Partly, I can see that. Let me see. You are in a very cold area of the United States. She's probably not going to like the winters there. So I can see from your caller ID where you're calling from. So yeah, don't have a preconceived intention. Let her come in, then decide after a few months. And then if you decide and you file her green card, she never has to leave. She can just stay here. Even if her tourist visa expires, tourist status expires, it's not a problem.
Okay.
All right.
Thank you, sir.
Oh, you're welcome. Good luck, sir. Next is Wink says passport correction for GC process. Birth certificate shows A country, passport shows B country. So the correct one is, let's see, birth certificate is A country. So I'm assuming that you were actually born. First of all, everything should be done truthfully. Whichever country you were actually born in, that should be your country all through. Look, if your concern is, will immigration check your passport? Yes, you have to submit a copy of your passport with the 485. Can we say we are in the process of passport correction? Yes. If you're getting the passport corrected, you shouldn't wait for the 485, for the passport correction to take effect before you file the 485. You can make the assertion, here's a copy of our application for correction. It's being corrected. I think you'll be okay with that. *5 Winks, if you're on the phone, you have a question. *5. Okay, there you are. I'm not doing new questions right now. If you're asking me a question that's new, put your hand down. Press *5 again. I'll get to that as soon as I finish the last question. Go ahead. Maryland, I have you unmuted. Do you have a new question or are you Winks?
Yes.
Oh, okay. Don't know what that meant, but all right. Let's go back to the last question. And this is a tough one. Isha says, what happens to the status of an H-1B worker whose company goes bankrupt? That's a very problematic issue. USCIS has struggled with it, but they've said that if you're not working, see, payment might be secondary, but if you're not working, then we have to assume that you are out of status. If you're getting reduced pay or your pay is spotty, at least an argument can be made. These are circumstances beyond your control, and maybe you can convert. Remember also, Isha, if you are on H1 and you lose status, your dependents also lose status. And there is no grace period for any of these situations. Today, you are out of status because the company went bankrupt. Well, let me rephrase that. If today the company went bankrupt and stopped your work and stopped paying you, Today you're out of status. There is no grace period here. *5 if you are on the phone and you have a follow-up question. *5. All right. Anybody has any questions? *5. Any question, new, old, doesn't matter. Please press *5 on your phones. I'm surprised you don't have any new questions. 1. There should be a lot more. There's a whole lot of you here. Okay. *5 on your telephone. 2 people. Okay. All right. Let me get started with Maryland, and then I have a anonymous caller that probably is a voice over IP. We'll get to that. So there's only 2 questions, no more. Very good. Maryland, go ahead, please. Maryland, I can hear you.
Yes, I just finished my obstacle practical training a month ago, but I got married during that period, and then my wife and I are starting to follow reforms, but I'm confused about 2 questions.
Okay.
I'm confused about my immigration status,
Okay.
USCIS status, and expiry date.
Okay. Let me explain to you how this works. Were you on F1 visa, sir? F1, F as in Frank?
Yes,
Okay.
and it's not expired until 2019.
Visa doesn't matter. Visa doesn't matter. Visa is a non-issue. Once your OPT expires, you have 60 days, 60, to either leave the country or change to another status.
Yeah.
Okay? So you don't have more time than that. Does that answer one part of your question?
Oh, please repeat.
I said, does that answer at least one part of your question? What is your current status? Your current status is F1 grace period.
F1 grace period.
Right. For 60 days from the date your OPT finishes, you have grace period in which you must either change status or leave USA.
And that's the same for the USCIS status?
USCIS status is what we are talking about. Visa doesn't matter. See,
what about the expiry date?
That doesn't matter. Once you are in the United States, only thing that matters is your USCIS status, what you're calling USCIS status. You could have visa up until 2020. We don't really care. If your status expires, you have to be out of here.
Okay.
All right?
So I could leave that blank. I could just leave that blank and then put F1 grace period as a status.
That's the only thing that matters. Your F1 grace period, which will be over in 60 days total, that's the only thing that matters.
Okay.
All right?
Thank you.
You're welcome.
And the lockbox.
Sure.
If I'm still in the US, should I send it to Chicago lockbox?
Chicago lockbox to do what?
If I'm currently in the US and I'm going to send off all these documents.
I'm not sure I understand what you're asking me. Your OPT is over. How would you stay in the USA beyond the OPT? Do you have another status in mind?
No, I'm currently on the grace period.
Right. So there's nothing to send to anybody. You just have to leave.
I believe.
Either you have to leave or you have to convert to another status that is available. For example, you can go back to school if that is available, or try to convert to tourist status if that is available. But you can't just stay here by sending your papers somewhere.
But I'm married.
Are you married to a US citizen?
Yes.
Oh, that is different then. I would suggest you look at, I'm not suggesting you don't get a lawyer. You can look at Form I-130 and 485, read the instructions. Those are the 2 forms that you will need. Once I-130, 485, along with all the other forms that go with it are filed, you will get your work authorization within about 3 months. You can continue to stay here, no problem.
so I can send the I-485 along with the I-130.
Yes, you will file I-130 and 485 together. Yes, sir.
But I could still use the F1 grace period on the status, right?
No, see, when you get married to a U.S. citizen, right now you are not out of status. But even if you were out of status, if you get married to a U.S. citizen, that's not a problem.
So what could I put?
I am not sure what you're asking. Are you asking me what to put in the form?
Yeah, on the status.
Well, your status is F1.
F1 alone.
Your status is F1. That's what you are in. Even till the grace period, till the grace period expires, you are on F1 status.
And I put the expiry date for the F1.
Sir, I cannot help you fill the forms. I can tell you that. You can call USCIS customer service, but if I help you fill the forms, then I have to sign the form as somebody who helped you fill the form. I can't do that. I can answer your questions, but I can't help you fill the form. Call USCIS. Okay?
Okay.
Good luck.
Okay.
Okay, sorry guys, we can never help fill the forms because there is a requirement that we have to actually sign the form that we helped fill. All right, last call of the day. Let's get this one. Anonymous, go ahead, please.
Hi, Vink. This is Vink. Rajiv, this is Vink. Are you able to hear me?
Yeah, Winks. 1 second. Let me pull your question. Passport correction. Yeah. Go ahead.
Yeah, my question is, my term is approved. I'm just going to apply I-140. My question here is, 40. My understanding is one for the employment verification, right? For that, do you need to submit my passport copy and the other member certificate?
1 second. You are the one who posted your questions as Winks, did you not?
Yes, right.
Okay, well, did you not hear my answer? I already answered your question.
Yeah, I got it.
Okay, wait for the recording. Wait for the recording. I should have it up by tomorrow. Your question has been answered completely. And I'll just give you the bottom line. If you are in the process of getting your passport corrected, you can just go ahead and file your paperwork, no problem. Okay, you don't have to wait for it to be actually corrected.
Sorry?
Sir, you should actually log in on time if you have posted a question. Now I'm repeating the whole thing again. You can file your papers without waiting for the correction to come through. Wait for the recording. If you don't understand it, you can call back in the next conference. Okay, I gotta go. Folks, it's good to see everybody and good to talk with you all. We'll see you again in 2 weeks. Please log in on time. Don't make me repeat myself. Thank you all. 2 weeks, we'll talk again. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.